Honorable Speaker, I'll say one last thing on that issue of the court order before I cede a few minutes to my colleague, Mr. Muriuki. Honorable Speaker, the issue of the court order that is the governor has alluded to is not to be looked at just as a standalone issue or as it is essentially, Honorable Speaker, an attack on the jurisdiction of this Honorable House to hear the impeachment motion that this House is seized of. The question, as I said before, is if a court whose jurisdiction is challenged, because in fact, Honorable Speaker, I was in those proceedings and the jurisdiction of the court was challenged. The court has not rendered a decision on a preliminary objection that was filed, but the court proceeded to grant the orders that were granted, and which court, the apex court in the Republic, together with the Court of Appeal, have held that our court is bereft of jurisdiction, take away the jurisdiction of this House, which is constitutional in nature. The jurisdiction of this House to oversight county assemblies is constitutional in nature. Can a court acting in excess of jurisdiction take away the constitutional mandate of this House? As Mr. Nyamodi quoted just before he took the stand, Honorable Speaker, the decision in Mark 4 on the validity of that court order comes into play. Because, Honorable Speaker, there is no need for that court order to be set aside. The moment that court order was given by a court that has disregarded binding precedents from the Supreme Court, from the Court of Appeal, and acted in excess of jurisdiction, that order is a nullity in law. So much as the court order says that the proceedings before the Assembly were a nullity in law, the court order itself is a nullity in law. There is no further order of court side that order, because that order itself is a nullity in law. It cannot stand. Therefore, Honorable Speaker and the Senators, I urge you, as I conclude, not to cede to the request, not to accede to the request by the governor's lawyers to take away the jurisdiction of this Honorable House on this important question that is before you for determination. I will cede the remaining minutes to my colleague, Mr. Muriuki.
Honorable Speaker, esteemed members of this House, my name is Eric Muriuki. I am privileged to appear before you once again. I represent the County Assembly of Isiolo. Honorable Speaker, esteemed members, continue with our submissions where my colleague has left off. The question that should seize this House, and Honorable Speaker, when you go to make your determination, is this: on a balance of conveniences, what ought to happen? We submit that this House ought to proceed with these proceedings because, as has been held in numerous court decisions, the governor will have the opportunity to challenge these proceedings in court. However, neither the court nor this House can freeze the statutory and constitutional timelines that are set for impeachment proceedings. So, Honorable Speaker, allowing the PO in the way that the governor's team asks this House to do would irreparably prejudice the Assembly, because there is a chance for the governor to challenge these proceedings, but there is no chance for the assembly ably submitted by my senior Nyamodi is after the process is complete. And Honorable Speaker, after the process is complete. And Honorable Speaker and members, this is what the court held in the case of Kawira Mwangaza versus the County Assembly of Meru. Honorable Speaker, this position was also buttressed or had earlier been held in the Mate, the Justice Kariuki Mate matter. Honorable Speaker, allow me to read an excerpt from the decision of the Court of Appeal, that is Mwangaza versus County Assembly of Meru and another, 2023 KECA. We observe that the applicant's right to be heard and to defend herself from the allegations made against her in the impeachment debate at the County Assembly of Meru provided under the standing orders of the County Assembly. If she is impeached, and emphasis on this part, Honorable Speaker, has the avenue of petitioning the court for an appropriate relief if the decisions were to go against her. We are therefore of the considered view that the applicant's right to be heard will not be circumscribed. Enough said, this court lacks jurisdiction to consider the application before it for the reasons stated in the ruling. That is the Court of Appeal, Honorable Senators speaking. The second question that this House and Mr. Speaker should ponder is, where is the public interest in this matter of the PO? This is an important question. The impeachment process has commenced. The Supreme Court and the Court of Appeal have, in very clear and no uncertain terms, they have forbidden lower courts from granting the kind of orders that the governor has brought here today, saying that he wishes to rely on to scuttle these proceedings. And, honorable senators, even where such orders are issued, what does the Supreme Court say? It says that should those orders be issued in error, then the assembly, the county assembly, is entitled to not immediately comply with those orders. Honorable Speaker, these are not my words. These are the words of the Supreme Court itself in the Mate decision. Paragraph 95 of that decision, and it is found in page 8 of our submissions, where the Supreme Court says, it is our understanding that the exceptional circumstances of this case, with a complex scenario of justiciabilities from contrasted standpoints, would lend justification to the non-effectuation of contempt orders at the beginning, and consequently, we would accommodate the reality of their not having been immediate compliance as would otherwise be required. The Supreme Court is recognizing that sometimes court orders are issued in error, and where the effect of those orders is to encumber a House of Parliament, a legislative house, from performing its duties, the Supreme Court is accommodating the reality that those orders do not have to be immediately complied with. Your honorable senators, on this basis, we therefore submit that it is in the public interest that this House dismisses this PO and proceeds to hearing, bearing in mind what the Supreme Court has said, what the Court of Appeal has said. Honorable senators, Another issue I want to touch on is the issue of forgery that has been alleged in the governor's preliminary objection. And the only submission I will add to what my colleagues have said on that issue.
Counsel for the County Assembly.
Yes.
Just take your seat. I've got a communication to make. Now, honorable senators, ladies and gentlemen, the time now is 1 p.m. And in terms of our program, we are set out in the order paper. We are set to adjourn at this time. I note, however, that the County Assembly still has 10 minutes of their time. I therefore wish to invoke Standing Order 34-2 and 2A of the Standing Orders, which permit the Speaker, for the convenience of the Senate, to direct later interruption of the business for a period of not more than 15 minutes. I therefore direct that the County Assembly may utilize its remaining 10 minutes so that the Senate shall adjourn at 1:10 p.m. or such earlier time as the County Assembly concludes its submissions. The Senate then will resume sitting at 2:30 p.m. when the Governor's Council will have its 10 minutes to respond before the Senate proceeds to make a determination on the preliminary objection. 5 contained in the accompanying flash disk. Copy of a public participation report dated the 25th of June 2025, laid on the table of the Assembly on Thursday, 26 June 2025, afternoon sitting, and a scanned copy of the report is contained in the accompanying flash disk. Written/printed memoranda from the different wards and regions submitted to the County Assembly during the public participation exercise on the motion submitted both in support and against the motion. The memorandum includes submissions received via email, minutes, attendance registration sheets, and registration forms for memoranda of the public participation forum held on Tuesday, 24th of June 2025, contained in the accompanying flash disk. And finally, a soft copy of the second edition Standing Orders of the County Assembly of Isiolo, contained in the accompanying flash disk. Honorable Senators, you may walk in and take your seats. Now, pursuant to Section 33(3)(b) of the County Governments Act and Standing Order 81A of the Senate Standing Orders, at a special sitting of the Senate held on Monday, 30th of June 2025, the charges against the Governor of Isiolo County, as contained in the motion of impeachment by the County Assembly of Isiolo, were read to the assembled Senate. Honorable Senators, violation of the Constitution or any other law, B, where there are serious reasons for believing that the county governor has committed a crime under national or international law, C, abuse of office or gross misconduct, or D, physical or mental incapacity to perform the functions of office of county governor. 2, Parliament shall enact legislation providing for the procedure for removal of a county governor on any of the grounds mentioned in Clause 1. Section 33 of the County Governments Act 2012, Senate Standing Order 80 and the third schedule to the Senate Standing Orders provide for the procedure to be followed in hearing and determination of the proposed removal from office by impeachment of a governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may either by resolution appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Honorable Senators will recall that at a special sitting of the Senate held on Monday, 30th of June 2025, the motion for the establishment of a special committee was deemed to have been withdrawn pursuant to Standing Order 70. This paved the way for default position, the hearing of the impeachment charges against the Governor of Isiolo County to be held in plenary. Honorable Senators, by way of status update, pursuant to Rules 4A and 6 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate invited the governor to appear and be represented before the Senate during its investigation. The Senate further invited the governor, if he so chooses, to appear before the Senate to file an answer to the charges with the office of the clerk of the Senate by 5 p.m. on Friday, 4th of July, 2025, setting out the following. 1, the governor's responses to the particulars of allegations. 2, the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3, the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And finally, any other evidence to be relied on. Pursuant to Rules 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate notified the County Assembly of the date for the commencement of the investigation and invited the County Assembly to designate members of the County Assembly who shall appear and be represented before the Senate during the investigation. The County Assembly was further invited, if it so chooses to appear before the Senate, to file with the office of the Clerk of the Senate by 5 p.m. on Friday, 4th of July, 2025, documentation 1, designating the members of the County Assembly, being not more than 3 members, if any, who shall attend and represent the Assembly in the proceedings before the Senate. 2, indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. Number 3, indicating the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And finally, specifying any other evidence to be relied on. On Friday, the 4th of July, 2025, the Office of the Clerk of the Senate received response reference number TW/LIT/027/2025 and dated 4th of July 2025 to the invitation to appear issued to the governor from Messrs. Theuri Wesonga and company advocates, who indicated that the governor had appointed the firm to represent him in the hearing before the Senate and that the governor would also appear in person and by advocates. The letter also indicated the list of counsel representing the governor and the list of witnesses for the governor. Similarly, on the same day, the Office of the Clerk of the Senate received a response reference number 1/CA/1-001/AB/25 and dated 4th of July 2025 to the invitation to appear issued to the County Assembly of Isiolo from Messrs. Alex and Boniface advocates, who indicated that the County Assembly of Isiolo had appointed the firm to represent the County Assembly in the hearing and that the County Assembly would equally appear in person and by advocates. The letter also indicated the list of counsel representing the County Assembly and the list of witnesses. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Clerk of the Senate furnished each party with the documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Honorable Senators, the hearing program, which has been appended to today's order paper, detailed the various activities in the hearing and determination of the matter and the time allocated to each activity. It will be crucial that all parties comply with the time allocated. The parties should keep track of the balance of time on each activity displayed through the digital clocks. In summary, the program states that today, Tuesday, the 8th of July, 2025, after we have dispensed with the preliminary matters, the charges against the governor shall be read. The governor will be given an opportunity to take a plea on each charge. This will be followed by an opening statement by the County Assembly and thereafter by the governor. After the conclusion of the opening statements, the presentation of the case of the County Assembly shall commence and shall not exceed 5 hours. At the sitting scheduled for tomorrow, Wednesday, the 9th of July, 2025, honorable senators will be given an opportunity to ask questions or seek clarifications from the County Assembly. Thereafter, the governor will have an opportunity to present his case before the Senate. The presentation shall also not exceed 5 hours. Honorable senators will also be given an opportunity to ask questions or seek clarifications from the governor. At the sitting scheduled for Thursday, 10th of July, 2025, the closing statements by the parties will be made for a period not exceeding 1 hour each. The Senate shall then proceed to a debate prior to voting on each of the charges. At this stage, a supplementary order paper will be published to facilitate this debate. In accordance with Section 33(7) of the County Governments Act 2012 and Standing Order 86 of the Senate Standing Order, the voting shall be by county delegations. The governor shall cease to hold office if a majority of the county delegations in the Senate vote to uphold any impeachment charge. If, however, the vote in the Senate fails to result in the removal of the governor, pursuant to Standing Order 87, the Speaker of the Senate shall notify the Speaker of the Isiolo County Assembly accordingly. Now, honorable senators, I now invite counsel for the County Assembly of Isiolo to introduce the legal team of the County Assembly and the members of the County Assembly of Isiolo representing the County Assembly by stating the full name and designation of each person. Counsel, you may proceed. Introductions only.
Thank you very much, Mr. Speaker. The legal team for the County Assembly of Isiolo is comprised as follows: Dr. Ekuru Okot, Mwereru Boniface Mawira, Mwirigi Eric Muriuki, Jamal Abdikadir, Chalo Kennedy Maweu, Paul Wafula, Kosgei Alvin Kemboy, Diana Nyaboke, Mugambi Mutua, Hassan Roba, Derek Kombo, Aromo Mariano, and Mr. Speaker, sir, I lead that legal team. The County Assembly is represented by the following members. I'm sorry, my name is Paul Nyamodi. Please excuse me for that. The Assembly is represented by the following members: Honorable Abubakar Abdi Godana, member of the County Assembly of Isiolo; Lematile David Letinina, Lorot Ewaton, Peter Loyan, Aban Kasim, and Abdikadir Ibrahim. Thank you very much, Mr. Speaker.
Senator Matinga, take your seat. Honorable Senators, I now similarly invite counsel for the governor to introduce the legal team representing the governor by stating the full name and designation of each person. You may proceed, counsel.
Honorable Speaker, on behalf of the Governor of Isiolo, we have the following team of advocates. We have Elisha Ongoya, who is leading the team. My name is Eric Veuri. We have Elias Mutuma. We have Tali Israel Tali. We have Marcelino Leisago, Miriam Rebecca Abong, advocate. We have Ms. Ruth Kiunga, advocate. Nura Abdul Kadir, Nura, advocate. Honorable Speaker, we also have Brian Lee Maindi, who is a legal assistant, Brian Gavi, a legal assistant, and Ali Fila, a legal assistant. Honorable Speaker, I believe that we had limited us just to introductions of the advocate. Thank you.
Senator Onyonka, take your seat, please. Now, honorable senators, on behalf of the Senate, I welcome the team for the County Assembly, the team for the Governor, members of public and the media to this Senate and to these proceedings. I invite the clerk to call the next order and thereafter read the charges against the Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County. Clerk, you may proceed.
Order number 2, reading of the charges on the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County.
The Honorable Abdi The Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, please take the stand. Please take the stand. Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, the charges against you as received from the County Assembly of Isiolo are as follows, and I quote, Ground 1, gross violation of the Constitution and other laws. 1, the Governor has grossly violated Section 30, subsection 2, paragraph K of the County Governments Act by failing to deliver an annual State of the County address for the 3 years that he has been in office. 2, the Governor has grossly violated Articles 201, paragraph D and paragraph E of the Constitution by employing a bloated workforce, including 36 advisors in the office of the Governor, 31 chief officers, yet the county has only 6 departments, and 2 deputy county secretaries whose positions are not known to law. This has created an excessive wage bill that is 46% of the annual revenue allocation, far beyond the 35% limit set by Section 25, subsection 1, paragraph A and paragraph B of the Public Finance Management County Governments Regulations 2015. 3, the Governor has grossly violated Articles 10, paragraph 2, 73, Article 232, and Article 235 of the Constitution, and Sections 59, 59A, 60, and 62 of the County Governments Act 2012 by disregarding the criteria for the establishment of offices within the county public service, by illegally creating offices for advisors and deputy county secretaries without the involvement of the County Public Service Board. 4, the Governor has grossly violated Articles 10, Clause 2, Article 185, and Article 201 of the Constitution by refusing to implement the recommendations and or resolutions of the County Assembly requiring the Governor to control and manage the county public debt in a manner that undermines the authority of the County Assembly, thus resulting in unmitigated accrual of debt to unmanageable levels. 5, the Governor has grossly violated Articles 201, paragraph D and paragraph E of the Constitution by failing to utilize bursary funds in accordance with the approved budget, resulting in a discrepancy of Kenya shillings 30 million, which cannot be accounted for. Ground 2, abuse of office, that the Governor has engaged in acts and omissions which singularly and collectively amount to abuse of office and gross violation of, among others, Article 201 and Article 232 of the Constitution, Sections 8, 9, 10, 11, 12, and 13(1) and 35 of the Leadership and Integrity Act 2012 by the following. A. Appointing 36 advisors in the office of the Governor, contrary to the Salaries and Remuneration Commission Circular dated 29th July 2013, the Transition Authority Circular dated 6th September 2013, and subsequent guidelines from the Intergovernmental Relations Technical Committee, all of which limit the maximum of advisors to 3. B. Appointing 31 chief officers instead of 18, which are provided for in the County Executive Staff Establishment of July 2022, yet the county has only 6 departments. C. Appointing chief officers under 2-year contracts, thus creating a climate of fear and uncertainty, which reduces public servants to be servants of the Governor and not the people, contrary to Article 73, Clause 1B of the Constitution. The Governor failed to renew the contracts of 31 chief officers and instead directed them to hand over to County Executive Committee members, significantly affecting the continuity of service delivery in the county. Appointing 2 deputy county secretaries, which positions are not known to law and are not in the county staff establishment. Ground 3, gross misconduct. The Governor has grossly violated 1. Articles 10, Clause 2, Article 27, Article 28, Article 73, Article 75, and Article 22 of the Constitution, and 2. Sections 3, 7, 8, 9, 11, 34, and 52 of the Leadership and Integrity Act. 3. Sections 9, 10, and 21, subsection 2 of the Public Officer Ethics Act 2003. 4. Sections 2, Section 30, subsection 2, and Section 30, subsection 3 of the County Governments Act, by engaging in acts which singularly and collectively amount to gross misconduct by the following. A. Making disrespectful, sexist, and demeaning statements against Senator Fatuma Adan Dulo publicly that are only meant to denigrate and degrade her as a woman leader, thus violating her right to dignity. The Governor's utterances do not demonstrate respect for the people and other public officers, nor do they bring honor, dignity, or maintain public confidence in the office he holds. The Governor's statements amount to gender-based psychological violence and undermine the dignity and the integrity of the Governor's office. B. Breaching public trust by making divisive, derogative, and discriminatory remarks against other clans residing in the county, thus undermining public confidence in the integrity of his office and sowing discord in the community. And C. Being continuously absent from the county and